what might America lose if what's long been considered a foundational tenet of how the country operates vanishes. These are the kinds of questions being asked more and more these days as more and more decisions by the U.S. Supreme Court seem to be taking apart the wall between church and state, brick by brick. Rory Little, constitutional law professor at UC Hastings, also a former clerk at the Supreme Court, with me now live to discuss what some believe is a disturbing trend. Welcome to Fox 40 News at 11.
Well, thanks. I'm happy to be here, although not particularly happy about some of these results. The Supreme Court had 4 cases this year. That's a lot on freedom of religion.
Exactly.
Three of them came out in a way that people might not like, and if you're progressive or liberal. One of them came out in a way people did like. So, for example, a death row inmate now has the right to have a pastor or a minister of some kind lay hands on them during an execution. And that was based on the freedom of religion of that particular prisoner.
We know the reversal of Roe v. Wade is a Supreme Court decision that's sort of front and center right now, many believing that, too, is all about religion and not about science. That decision has kind of eclipsed the one you just mentioned and some other recent activity by the high panel. On June 21st, the conservative majority ruled the state of Maine could not exclude religious schools from a tuition assistance program, allowing parents to use vouchers to send their kids to public or private schools. Now, this really kind of amounts to an expansion of religious liberty, right? I think the average citizen would have thought this would be a definite no-no at first blush.
Yeah, and not only that, but Maine, states may have the discretion to equally fund religious schools if the political process leads them there. This opinion requires the state of Maine to fund parents' decision to send to private schools, even if the state and the political people in the state don't want that. So it puts this freedom of religion claim and this failure to establish this wall sort of above the political democracy rights, if you will, of the people of the state of Maine and other states like them.
Well, this week, the same 6-3 majority on the court found in favor of Washington State public school football coach Joe Kennedy. Kennedy had lost his job for praying at the 50-yard line after games. In Maine, we're seeing public money, state money go to religious institutions. And then this one is a case of prayer being allowed at a public school event.
Yeah, again, up until now, it's been a relatively clear rule that during public school events and public school hours, you can't have a display of a religious exercise. And that is because the First Amendment says the state shall not establish religion. This really makes it very confusing if you happen to be a school administrator, because this football coach, the court says, oh, it was a private display of religious exercise. Well, it wasn't very private. Justice Sotomayor put a photo in of all the people crowded around this coach at the end of the game. And now you've got the claim of a bunch of other people who want access to that 50-yard line, Satanists actually in the same school district, Muslims, Jews, other religions. They now have the right, if you will, to demand access if a Christian prayer gets access.
Right,
That's
exactly.
Pretty disturbing.
Controversial U.S. Representative Lauren Boebert of Colorado was speaking to a church group in her home state this week and said, quote, "I'm tired of this separation in church and state junk. That's not in the Constitution. It was in a stinking letter," unquote. Again, that's a direct quote from her. So what is the answer? Well, President Thomas Jefferson did write a letter in 1802 to a Baptist association saying America had built a, quote, wall of separation between church and state. Before that, the concept of separation between church and state kind of was derived from what you mentioned, the Establishment Clause in the Bill of Rights, which says Congress shall make no law respecting an establishment of religion. And Roger Williams, the founder of Rhode Island, is regarded kind of as the first to point out this separation. Supreme Court's applied the clause to states with the 14th Amendment and has used the doctrine to uphold the separation. So for the rest of us non-lawyers, in the Constitution or not, is it really what we're supposed to be operating on, or is this just a notion, a convention that's been held for a really long time?
Well, most people think it's firmly in the Establishment Clause of the First Amendment, just as you just recounted. It's never been a perfect wall. We still say under God during the oaths. Ketanji Brown Jackson was sworn in a few hours ago as the first black woman on the Supreme Court. She said under God at the end of her oath. We have it on coins and things like that. But for the most part, in public schools particularly, there's been a really strong separation. This throws the clock back, if you will, 50 or 60 years.
Representative Boebert, that we were just talking about with her comments this week, got a lot of applause where she was speaking, said, quote, the church is supposed to direct the government. The government is not supposed to direct the church. That's not really how our founding fathers intended it, according to her. Seems to be a presumption here that her church, their church, the people she was speaking to, is the denomination that should be in the driver's seat in terms of directing the government. But if America starts allowing the church to direct the government, the question becomes, which church, doesn't it? America wasn't set up as a theocracy. I mean, the Taliban is a theocracy.
You're absolutely right. And one somewhat, crazy representative in the House of Representatives, the 435, she's not running the show, but her view is just flat out wrong. And even the conservative justices would say that she's wrong about that. The Establishment Clause makes this clear. And it's designed to avoid the divisive effects of a religious society, including people who hold spiritual views, but they're not religious views. How do you draw the line? If you're a public administrator, it's almost impossible. That's what the Establishment Clause is designed to prevent. Yes, you have the right to free exercise of religion, but not in a public sphere, not in a public place. There was one other decision, by the way, where they said Austin City Hall can't exclude a Christian flag if they put other flags up at their city hall as on a sort of a momentary basis. So again, you've got the sort of combination, if you will, of church and state in that case.
And so where does the country go from here? If you can say that the conservative justices would definitely say that what Representative Boebert is saying is wrong, and yet they seem to be the ones, muddying the waters the most when it comes to what everybody has thought was this established tenet. So where do we go from here?
Well, we never know exactly where we're going, right? We will see further litigation about all of this, that's for sure. We will see a new justice possibly changing the dialogue. She won't change the ideology balance, but she'll change the dialogue. She's 35 years younger than Justice Breyer. And you may see future appointments in the presidential sector. This is why politics is as important as law at this point, and trying to have a political result that doesn't go to the extremes is really what we've all got to be working for, I think, as a matter of law and as a matter of our constitutional system.
Well, it is a huge issue, and we're going to have to put a pin in it there for today, but thank you so much for your insight.
My pleasure. Thank you. That was you know a lot about the law. It's very clear.
All righty. Thank you so much. I appreciate the compliment. And we